नमस्कार, आदाब, सत श्री अकाल दोस्तों। स्वागत है आपका एक बार फिर से हमारे YouTube चैनल ब्रास फ्यूजन्स पर, जहां हम आपके लिए एक बार फिर से लेकर आए हैं एक नया लेसन।
And there once again the court uses that to say that inadmissibility confined to the income advice. The material is still subject to judicial scrutiny. Therefore, Article 74 Clause 2 is confined to the aid and advice. And this is a way, I think as students of law, there is one lesson I think that we can draw. How broadly you construe the word or how narrowly you construe the word is entirely dependent on what your overall mission is. So we say, for example, that all criminal statutes are interpreted narrowly. That means that we want to give greater expanse. We don't want to give a liberal interpretation to criminal statutes, because then more and more people would fall within the criminal law and would be sent away to jail. So a democratic impulse requires us to interpret taxation laws, you want to save people's money, and criminal law because you want to save people's liberty narrowly. Yet social welfare laws, which give benefits to people. So it could be a social security law, it could be now the labor laws. I can't take the name of IT Act anymore because once the president signs it, I don't know if he signed it as yet. I've not read today's newspaper, but till yesterday it had not been signed. It would then come into force, and then our old labor laws would, of course, be replaced. So we have a council of ministers that aids and advises the president in his functions. We want to find out one answer. Does the president have any freedom at all to determine any things? One freedom is made explicit in the proviso to 74.1, because certainly if the president is returning a file, he is certainly acting on his own. And when he acts on his own, is it permissible for him to take the advice of the foremost law officer of the government? Who is that? Who's the principal? Attorney General. Attorney General, yes, he can take the view. He can also take any other. Now, let's now look at Article 154, okay, because I just want to look at it. Under Article 154, executive power of the state shall be vested in the governor and will be exercised by him either directly or by officers subordinate to him. So we notice both in 53 and in 154, by him or by officers subordinate to him. Who are those officers subordinate to him? We notice that in Article 77, that all executive action is taken in the name of the President of the Union of India, all executive action. 77, where am I? Right. And 77.3, President shall make rules for more convenient transaction of business for the allocation amongst the ministers. So all executive action of the President is taken by officers subordinate, but in the name of the President. Is there a delegation between the president and these officers? And the answer is no. Why is the answer no? Because 77 says all action is taken in the name of the president. So he has not delegated the powers to the subordinate. It can be the minister, it can be the secretary in the ministry, additional secretary, joint secretary, it can be the lower section officer, whoever it is in the judicial bureaucratic hierarchy operates in behalf of the president. They are not delegates. They are actually as if the president himself, only under rules made under 77.3, somebody else is doing the work, but everything done in the name of the president. This is quite important principle for us, because it shows us that executive action still is done in the name of the president. There is no delegation. And therefore, the minister can give to the secretary can hand over the file to additional secretary. All of them are operating in the name of the president. And this is important from another point of view for us. When you look at administrative law, there is a Latin principle called delegatis non pote delegare. A delegate cannot further delegate unless the further delegation is once again authorized by the first person who exercised the power. Because of the legal fiction that there is no delegation down the bureaucratic chain, you can just keep, the government can make an order saying for these reasons, allocation of government houses will be done at the level of the joint secretary. Dismissal will be done by the secretary. You can have office orders allocating which officer will do what, but there is this kind of thing is not called delegation because they're all being done in the name of the President of India, and it also saves us Okay, that's the Latin principle. Okay, delegatis non pote delegare. That is, a delegate cannot further delegate. So we are now liberated from the embargo of this legal doctrine because everybody is still doing it. Now, do the principles of admissibility apply to the advice offered by those who act on behalf of the president? Yes, they are all bound by the Official Secrets Act. They in turn are bound by other principles, not by the principle of 74(2). That's very easily done. You know that whether it's a minister or any bureaucrat who takes up a job, you are bound by the Official Secrets Act. The only exception to the Official Secrets Act is, in one sense, the RTI Act. Okay, and very interesting parliamentary debate, let me tell you, when the RTI Act was being enacted about what would be the possible dilution of the Official Secrets Act. You know that the oath of office, every minister also takes the oath under the Official Secrets Act. Official Secrets Act automatically applies to all public servants, so there's no problem. You don't have to take an oath. Minister, yes. And of course, after the M. Karunanidhi judgment of the Supreme Court, the minister also will be a public servant. But in any case, the tradition of having that oath has always been there. So the president is under the aid and advice. Now look at Article 163, and I want you to note that these two provisions are not symmetrical. And we want to see why they are not symmetrical. Look at Article 163. Okay, there shall be a council of ministers. I'm reading 163 clause 1. There shall be a council of ministers with the chief minister at the head to aid and advise the governor in the exercise of his function, except insofar as he is by or under this constitution required to exercise his functions or any of them at his discretion. Okay. So just read it. You will now appreciate why I say there is an asymmetry. The president exercises all his functions. Off with your camera, please. President exercises all his functions on the aid and advice. His functions. Yet the provisos carved out one exception. Are there others which are unacknowledged? Shamsher Singh is going to give us the answer to that. And when you read Shamsher Singh, don't just read the edited Shamsher Singh, which is the judgment of Chief Justice Ray for himself, or Justice Ray, who is not Chief Justice then, Justice A.N. Ray for himself and 4 others. Read the separate, concurring, and most brilliant judgment of Justice Krishna Iyer for himself and Justice Bhagat, because that actually addresses and gives you the answer to the question I'm currently asking. Is there an implied area of discretion that the president has other than this proviso? Proviso, of course, came after this judgment, okay, but in any case. But when it comes to governor, what does it say? Normally, the governor is bound by aid and advice, except insofar as this constitution says he is required to exercise his functions in his discretion. Okay, in his discretion. But there are other phrases used by the Constitution. Okay, and just because this is dealing with the state, what is a state is not defined in our Constitution. There is no definition of state. But Article 367 tells us that wherever you have any doubt, you can follow the General Clauses Act. Please look at 367 after my class. I'm not opening it up now. But it tells you that you are able to look at the General Clauses Act. It has been officially put down in our Constitution. And that has a definition of state. Because the General Clauses Act is an old act of 1897. If you look at the definition of state, it says state A, B, C, etc. At that time, there was A, B, C. British rule India. Chief Commissioner's province was C. So Delhi was a Part C state. And then finally, we also got Part D, which was Andamans and Nicobar. Okay, those are the 4 states. But after the 7th Amendment, we now have only state and union territory. But we still don't have a definition of what is a state. But the word is used all over the Constitution, so we know generally it means the whole provinces. But there is a definition for union territory in our Constitution. Where will I find the definition of union territory, please? Anybody?
Article 366, number 30.
Very good, very good. Exactly. You will find it there. It is in the definitional section and it defines it. Now, those union territories that have a legislative assembly, which also has a chief minister and minister. So you have some union territories that don't have all these things. They only have an administrator who is operating on behalf of the president. But those union territories that have a legislative assembly, which have elections, so Puducherry has a chief minister, Delhi has a chief minister, it has a council of ministers elected, and that council of ministers also is responsible back to the legislative assembly. There's a principle of parliamentary democracy there. Now look at Article 239. Okay, and it's a very long article, so we must look at it correctly. 239AA. Okay. 239AA, 2 small a says there shall be a legislative assembly. And then it says, look at 239AA subclause 4. Okay, don't get lost in 239. It runs for pages and pages. Okay, 239 capital A subclause 4. There shall be a council of ministers consisting of not more than 10%. Remember, I told you 15 in Parliament and state, 10% here. Here it is. Not more than 10% of the total number of members of the Legislative Assembly, with the Chief Minister at the head to aid and advise whom? Not the governor, not the president, but the NG. So there is an aid and advice here. So there are 3 places of aid and advising: president, governor, as well as NG. But the president also can take other advice. You already noticed that in 75 clause 1, he takes the advice of the Prime Minister with regard to the appointment of the ministers, because he shall appoint the ministers based on the advice. The president also takes advice under Article 103. So look, the president takes lots of advice. Look at 103. What am I trying to do? I'm trying to map all the places where president takes advice. And look at 103. From whom is the president taking advice here? If any question arises about the disqualification, whether a person of either House of Parliament is subject to any disqualification, the question shall be referred to the decision of this president, and his decision shall be final. But in this case, the president is not going to take aid and advice from the Council of Ministers. Excluded. And there's a political reason, because maybe the ruling party MP is getting disqualified. How will the objective advice be given by the Council of Ministers? And therefore, it tells you 103 clause 2, that you will obtain the opinion and shall act according to such opinion. Look at that, shall act according to the opinion of whom? The Election Commission. So in order to prevent political overtones to this advice of disqualification under 103. So when we say aid and advise his functions, the president's functions are broad. One set of functions bound by the aid and advice of the Council of Ministers. In one, not the Council of Ministers, but just the Prime Minister 75. The second, 103. And then there are where he acts suo motu on his own. Which are those? Shamsher Singh. Okay. But now, let me also... So discretionary power, you're right, Rupanshu, is broader than that of the president. I'm going to leave the president for just a moment and move to the governor and then come back to the president again. So if there is a governor in the state, there is a governor in the state who is appointed. In that appointment, does president act alone or does he act on aid and advice? I'm going to defer that for Monday after you've all read Shamsher Singh's case. I'm now coming to the governor. Governor also discussed in Shamsher Singh, but I want to discuss. Now, Shamsher Singh tells us that when there is a governor, and the governor is to act in his own capacity, in his own name, eo nomin, that is in his own name, then we must say that in these areas, the advice under Article 163 will not apply. Now, what are those areas where the governor exercises his own discretion? And the question that arose in Shamsher Singh, and I would really urge many of you to read this carefully, because this is a case of two judicial officers who got appointed to the judicial service under Article 234 of Punjab, and both of them lose their jobs. And in both their cases, the Supreme Court feels that their termination was bad in law. But the termination letter was issued in the name of the Governor of Punjab, that the Governor of Punjab is pleased to dispense and terminate your services, because all government employees hold their office during the pleasure of the president. And government employees are, of course, the members of the bureaucracy, but because many of you I know are going to be writing judiciary, know this also, that under Article 234 and Article 235, they would be also governed by the provisions of Part 14 of the Constitution dealing with Article 311. So let me just introduce this a little bit so that when you read it over the weekend, you're not going to get confused. Anybody who is a bureaucrat and who's appointed your IAS, Central Civil Service, whatever, legal service, whatever, you are bound by the services under the state and chapter under Part 14 of the Constitution. You hold your office in the pleasure of the president. And Manu, I'll be very brief because this is actually something we study in semester 2. Pleasure means that I am pleased with you, you continue in service. I'm not pleased with you, you will be dispensed with. That is, you are completely at the pleasure and mercy of the president. This used to be the doctrine of pleasure under the British Crown. I don't like you out, I like you in, But in a constitutional scheme, obviously, this arbitrariness will not work. And Article 311 is therefore a complete constitutional code with regard to government employees. And what does it say? Two very broad principles. You cannot be dismissed by an officer junior to the person who appointed you. Number two, before you are terminated for a misconduct, you must have an inquiry held where you had proper chance to participate. And in very exceptional circumstances, on limited grounds of security of state, etc., you could be terminated without there being an inquiry. So some principles of natural justice have been read into by our constitutional provision to limit that doctrine of pleasure. Those of you, and I would urge you to study the service law, which is what we teach in services under the state, is a wonderful area of law. It's one of those areas that I have studied myself and written on in a great deal, because it has the principles of constitutional law, some elements of administrative law, and also some elements of labor law. But we don't call it labor law. Labor law is for those in the private sector. For those under constitutional protection, we call it service law. Okay, and so that's the distinction we make between service law and labor law. And service law is a fine area. Currently, if you ask me, which is the area where maximum number of writ petitions are being filed, you will be surprised that it is not under government servants, but it is armed forces. In fact, at some point in time, there were more than 10,000 petitions pending all across India under Article 136 filed by members of the armed forces. So, about 10 years ago, the government has now set up the specialized. You know where the headquarters of the Armed Forces Tribunal are? No? Armed Forces Tribunal? Have you heard of the Armed Forces Tribunal?
From New Delhi.
Yeah. So, in fact, the Armed Forces Tribunal is an area where maybe some of you could try. And once we are over with this terrible COVID crisis, I would urge you to consider a internship in the Armed Forces Tribunal. Okay, it's worth it. Now, let me just take one more minute. I have only 5 minutes I need for attendance. 311, therefore, is a constitutional limitation on the doctrine of pleasure, and it says you can't appoint and dismiss at your own sweet will, President, but there must be an inquiry, and it's only in exceptional cases that you can bypass that inquiry. Broadly, that's 311's key feature. Now, these two judges were terminated while on probation. So we have a little more complicated question, but it's a lovely question of service law. If you are on probation, you need not be made permanent or regularized if your performance is not satisfactory. Okay? Maybe you were appointed as a typist, और फिर बाद में पता चला that like many of us, you're only a two-finger typist. नहीं चलेगा. Right? You have to be able to do little brown facts, jump over the fence, or whatever is that word, lazy dog, or whatever. Those kinds of words very quickly. And you can't do it. Then your work is not satisfactory. However, during probation, not that your work is not satisfactory. You decide to run away with some, you're entrusted with 1 lakh of rupees, or aap usko dafa kar dete ho. Run away with it. Then that is a misconduct. For misconduct, you must have an inquiry and you must have a chance to speak, and then you can be dismissed from service. So one is being asked to leave because your work is unsatisfactory, and the other person because of misconduct. Now, in both the cases, the law on the service law is slightly different. And in both cases, the Supreme Court finds problem with the termination of a probationer and the kind of inquiry that happened. And therefore, these two judges who were terminated, their termination was held to be not correct. That's the factual situation for us there. But in the course of that, the question was, in the name of the governor, they were terminated. But the governor never had any look at the file at all. In the name of the governor, but the file just moved at the lower levels and they were terminated. Is this a violation of Article 74? Should the governor have independently applied his mind, or was he bound by faith and advice? And if the answer is yes, still should he have signed that file, or was it sufficient if the subordinate signed? There are these two questions we have to study. You all to read it very carefully. I would say read it at least 2-3 times. Okay, and underline it, mark it, and read Shamsher Singh. So for this part of the thing, Justice A.N. Ray's judgment is enough. But for the second question, question that I'm going to examine. What is the discretion of the governor under 163? Read Justice A.N. Ray. Enough. But for that last question, what is the discretion of the president? That stands where the president acts without that aid and advice. You will have to read Justice Krishna Iyer's Sampari judgment. Okay? So let me stop here and take attendance.
Ma'am, I had a question, ma'am. May I ask?
Yeah, quickly, if I can answer it also quickly.
Ma'am, I just had a doubt with executive action. The I got the case, Ram Swarup, but what is executive action exactly? Because.
Okay, that I can't answer. That I will in 1 minute. We'll continue with that. Okay?
Okay, ma'am.
Yeah. Nitin Kumar, Hemant Singh, Praveen Rajesh, Himanshu Singh.
दोस्तों, अगर आपको आज का लेसन पसंद आया हो तो वीडियो को लाइक करें। इसी के साथ अगर आपने अभी तक हमारा चैनल सब्सक्राइब नहीं किया है तो सब्सक्राइब के बटन पर क्लिक करिए और बेल आइकन दबाना ना भूलें, ताकि आपको एजुकेशन से रिलेटेड नए नए अपडेट्स मिलते रहें। और अधिक जानकारी पाने के लिए आप हमारे फेसबुक और इंस्टाग्राम पेज से भी जुड़ सकते हैं, जिसका लिंक डिस्क्रिप्शन बॉक्स में दिया गया है। धन्यवाद।